Hello, everyone. My name is Tommy Grooms. I'm a staff attorney here at the clinic. And for today's Coffee with the Clinic series, I'll be giving you a general overview of the Department of Child Services. I want to start by with a caveat that this presentation is intended as public legal education. It's not meant to be case specific. I'm not your attorney, and we haven't created an attorney-client relationship. And I strongly advise you to contact an attorney in your area to discuss the specifics of any case you might have. The most up-to-date information on the clinic intakes can be found on the clinic's website, www.nclegalclinic.org. So I'll go with that out of the way. I'll go ahead and start the presentation. If you have any questions, you can leave them in the comments, and I'll try to address them at the end. So what is DCS, the Department of Child Services? It's a department that was established in January 2005 by executive order. It is charged with overseeing child welfare and child support enforcement. It protects children who are victims of abuse or neglect and provides services focused on family support and preservation. It administers child support, protection, adoption, and foster care. So the department actually does quite a lot, even though some people view it in kind of a small lens as the place that will take away children who are being abused. That's really just the stuff that gets kind of the most publicity, but they really do quite a lot in all areas related to child welfare. My experience is in facilitating litigation from DCS against parents and otherwise helping the department navigate legal requirements in pursuit of its mission. That was my job for about 5 years before coming here to the clinic. So that's the perspective and the lens which I'll be approaching things today. So what most people are familiar with is that aspect of removing children from their parents or guardians. It is an extreme step, and it is proven to always be traumatic to a child. There's no way to remove in a way that isn't going to traumatize a child in some way, shape, or form. DCS can make emergency removals where they can just come in and take a child without getting some kind of court order beforehand, but they have to have a detention hearing within 48 hours to prove that they have probable cause for the removal. Removal of the children doesn't have to be at the beginning of the case. It can be ordered at any time in a DCS case if the safety of the child has been implicated in some way, and the judge gives that order. Although an emergency removal can also happen at any point in the case. Obviously, if a DCS worker were to come across a situation that they felt was a danger to the child, they do have the ability to, again, make a removal and, again, have that detention hearing within 48 hours. In any decision that's made in a DCS case, the best interests of the children are always considered. And in the case of removal, preference is given to placement with family or to those with a close relationship with the children. When they're not blood relatives, that's called kinship care. And all of that is done before foster care is considered. So foster care is sort of like a step 3 or 4 down the line as far as what DCS considers when it comes to placement. It will always prefer that the children maintain or stay with someone who they already have a relationship with. And to that end, separating siblings is something that is always tried to be avoided. So not every case involves removing a child from parents, but it is how a lot of cases start. And the department's priority is child safety, and children do remain in the home with parents whenever their safety will allow it. So, children in need of services. This is a very important phrase in DCS cases. DCS often works with families without or with minimal court involvement, but DCS can bring a civil case, a child in need of services case, against parents or guardians of children who the agency believes are in need of services. The statutory basis for this is Indiana Code 313413. It defines child in need of services. And just for the sake of convenience, I'm going to start saying CHINS from now on, because that's typically the abbreviation how it's referred to. And the most common definition of a CHINS is a child who needs care, treatment, or rehabilitation that the child is not receiving and is unlikely to be provided or accepted without the coercive intervention of the court. The coercive intervention of the court, that's another important phrase. It's basically what it says that the court can order a parent to participate in services. When a case starts before a CHINS is proven, the court can't actually order parents to do that. It can incentivize parents to engage in services in order to get parenting time with the children, but it can't actually order parents to participate in services until that CHINS is proven. And in general, this is what's important to understand about CHINS cases, is that it's part of an adversarial system of the law itself. The law has to balance the rights of parents with the best interests of children. And sometimes those aren't in conflict, but sometimes they are. So to that end, there are hoops that DCS has to jump through to prove that they can continue to be involved in the case and make sure that children have all their needs met. To get a CHINS ruling, DCS has to prove that a child is a child in need of services by a legal standard called preponderance of the evidence. Another way to think of that is more probable than not. And they have to prove that within 60 days, which can be extended to 120 days if the parties agree, to prove the child is a CHINS in a fact-finding hearing, which is another way to say in a trial. So 60 to 120 days, DCS has to have a trial to prove that they deserve to be involved in the case. So this is something that's in place to help protect parents and their rights, but also takes into account that DCS's services are needed in many cases, and it just shows that they have to prove it. Now, preponderance of the evidence is not a difficult standard to meet. It just means like 51%, if you think of it as a scale. If it tips a little bit more towards DCS than towards the parents, DCS will win that case. The standard in a criminal case, a phrase that you've probably heard, is beyond a reasonable doubt. That's a very, very high standard. In a civil case, the standards are lower. But even though that standard is lower, unlike most civil cases, parents in DCS cases have a right to counsel. Typically, a right to counsel is something you only get in a criminal case where there's a threat that you would be deprived of liberty by being imprisoned in some way. But in this case, the American law, American jurisprudence has determined that the parental rights are rights that are right up there with right to liberty, like being at least in this instance, you have a right to counsel in a civil case because the parental rights are that important. And the system further tries to promote child safety and the fairness between the systems by not saying that DCS necessarily has the last word on the best interests of the child, but children themselves are appointed an advocate in court called a guardian ad litem. This is a volunteer that the court appoints whose job is just to announce to the court the needs of the children and make sure that their specific wants are advocated for, depending on the age of the child. That is weighed more or less heavily. So, in an outcome of in a CHINS case, there are various outcomes. In some cases, the CHINS lawsuit is never actually filed because parents are willingly working with DCS with very minimal court involvement in what's called an informal adjustment. That means that parents are voluntarily participating in services with DCS, and the coercive intervention of the court ordering parents to participate, is not something that's needed in order to get the child to a place where the child is going to be safe in the home with parents. Sometimes DCS will file a case and it will later be converted into an informal adjustment, or DCS, if it determines that before adjudication, before that trial, that if they no longer believe a child to be in need of services, they'll go ahead and dismiss the case. Sometimes they dismiss cases because they believe the child to be safe. Sometimes they dismiss even though they want to stay involved, but they don't think they have enough evidence to go forward with a trial and win. The first goal of a CHINS case is always reunification, is always trying to get the child back in the home with parents. And even after a CHINS ruling is made and parents are ordered to participate in services, parents do often successfully complete the court-ordered services and families are reunited. However, sometimes not. Sometimes parents don't always participate in services, and the permanency of the child has to be considered at that point. Because the first goal is always reunification of the family, but the adjacent goal is always permanency. Putting the child back in a home with parents is ideal, but the big goal is permanency, getting the child to a place where they are going to be secure and safe and flourish. So parents don't get infinite bites at the apple. They don't get to keep trying until they get it right. At a certain point, the law says the child's needs for permanency outweighs the rights of the parents to keep trying. The first sort of timeline set on that, apart from that timeline to get with that 60 to 120 day timeline to get that trial, is that when a case has been open for at least a year, the court is required to hold what's called a permanency hearing. And at that point, the plan can change from reunification to adoption. When the plan changes to adoption, DCS will then file a new civil suit called an involuntary termination of parental rights. This is sort of just like the CHINS process in that sense that it's a new filing. And with a new filing and under a new area of law comes a new set of standards. DCS has to prove by clear and convincing evidence that parents are unlikely to make progress if services continue. If you'll recall, the standard to prove a CHINS was a preponderance of the evidence. Clear and convincing is harder. It's still not quite as hard as beyond a reasonable doubt, but it is a tougher standard to meet. So the law takes termination of parental rights very seriously. It doesn't just terminate them out of hand. And even while a TPR trial is pending, even after that involuntary termination of parental rights suit is filed, it's still possible for parents to turn it around, to show improvement, and for a plan to change back from adoption to reunification and eventually be dismissed. But when that doesn't happen, the plan is adoption. And DCS typically does not proceed with a TPR petition without an alternative placement already determined. DCS also assists in finding permanent placement for children. Sometimes this is with family members, other times this is through kinship care, or through foster care and adoption. And DCS does a lot in terms of trying to determine what homes will be best for the children in terms of a long-term and adoptive placement. Sometimes the family a child is placed with is not the same family they were placed with at the beginning of a case, the same foster family. For whatever reason, sometimes that foster family can't take on caring for the child for a long term in a pre-adoptive context. At that time, DCS looks around for a pre-adoptive family who can take care of the children in a plan that will eventually lead to adoption. So that's a CHINS case, all the way through to a TPR case. There's a lot more nuance and different roads that, of course, can take, but that's sort of the basic pattern. And we'll probably try to explore some of those areas and aspects of a CHINS case in more detail during later Coffee at the Clinic series. But I wanted to leave you with a couple of resources. First of all, the Indiana Child Abuse and Neglect Hotline, 1-800-800-5556. What's important to know about Indiana law is that it's a mandatory reporting state, which means that anyone who suspects that a child has been neglected or abused must make a report by state law. It's not some special duty of like a parent or a coach or your position in society doesn't matter. If you are aware that a child is being abused, you're obligated to report it in Indiana. And that's the number to do it. If you want more information about DCS and the DCS process, you can go to DCS's website, www.in.gov/DCS. Also, if you're interested in volunteering as a guardian ad litem and being an advocate for children in a courtroom and during a DCS case, you can contact the Indiana State Office of GAL/CASA at 1-800-542-0813. And there's always a need for foster parents. So if you're interested in becoming a foster parent in Indiana, you can visit www.indianafostercare.org. I don't think I've received any questions. So I think at this time I'll go ahead and end the chat. Our Coffee in the Clinic is held on the second Tuesday of every month at 11 a.m. Our next topic is an immigration-related topic, traveling outside the U.S. Is it a good idea? I'd encourage you to follow the clinic on Facebook to get notifications of future legal education presentations. So thank you, and I hope this presentation was useful.